Pre-election litigation is a special type of court case in Nigeria. It deals with disputes that happen before the day of a general election. These cases are fundamentally about the process of selecting a candidate. They are not the same as election petitions. Election petitions happen after the election is over. They challenge the conduct of the voting itself, the collation of results, the final declaration of a winner. A pre-election case focuses on internal events within a political party. It examines whether the party followed the law when it nominated its flag bearer. It is a critical tool for internal party democracy. The most common source of pre-election lawsuits is the party primary election. A primary is the internal contest held by a political party. Its purpose is to choose which member will represent it in the main election. An individual who participated in the primary but feels cheated may go to court. Not just anyone can file a pre-election case in court. The law is strict about who has the right to sue. This right is called locus standi, or standing. In pre-election matters, the person with standing is the aspirant. An aspirant is someone who actively sought a party nomination, purchased the nomination form, went through screening, participated in the primary election. Courts want to see a direct personal stake in the primary outcome. If you did not participate, the path to court is much harder. You must prove you were unlawfully excluded. Example, show you bought the form but were wrongly disqualified. A mere party member who never tried to be a candidate cannot challenge. Courts view such people as meddlesome busybodies. Law protects those directly involved, not endless challenges. Courts are reluctant to interfere in internal party affairs. Purely domestic party squabbles will likely be dismissed. In the world of pre-election litigation, time is of the essence. The law imposes very short and strict time limits for filing these cases. This is not an area where delays are tolerated. The entire process is designed to be swift, ensuring nomination disputes are resolved long before voters go to the polls. If an aspirant misses the deadline, the court loses the power to hear the case. Evidence or justice won't save a late filing. A case filed even 1 day late will be dismissed. Act immediately, that's the critical advice. The clock starts ticking from the moment the wrongful act occurs. Legally, that's the date the cause of action arises. It could be the day a flawed primary was held, or the day the primary result was officially announced. In unlawful substitution, it starts when the party submits the new name to INEC. Section 285(9) of the Nigerian Constitution requires filing within 14 days. 14 days is a very short window. No room for hesitation or procrastination. Section 4. Picking your battlefield. The question of court jurisdiction. Choosing the correct court to file a pre-election case is a critical strategic decision. Filing in the wrong court can lead to the case being struck out, wasting precious time and resources. The power of a court to hear a specific type of case is called jurisdiction. For pre-election matters, the Constitution and the Electoral Act give specific guidance on which courts have this power. Not all courts in Nigeria can entertain a dispute arising from a party primary. Getting this choice right from the very beginning is fundamental to any chance of success in the legal challenge. For the most part, the Federal High Court is the primary court with jurisdiction over pre-election matters. This is because these cases often involve the interpretation and application of federal laws, such as the Electoral Act. They also frequently involve federal agencies, most notably INEC. The Federal High Court is specifically empowered by the Constitution to handle disputes related to the nomination of candidates for election. Therefore, in the majority of situations, an aggrieved aspirant should direct their case to the Federal High Court in the state where the primary election took place or where the relevant decisions were made. However, the legal framing of the case can sometimes influence the choice of court. Section 5. The path to justice. Steps in a pre-election court case. The procedure for a pre-election lawsuit is designed for speed. It follows a series of defined steps, each with its own timeline. The journey begins the moment an aspirant feels wronged. The first unofficial step is to gather all relevant facts and evidence. This means collecting documents, taking photographs, recording videos, and getting written statements from witnesses who were present. This evidence must be preserved carefully. It will form the backbone of the case. Do not wait until you are in court to start looking for proof. The preparation must start immediately. The first formal step is filing the originating process. This is the set of documents that officially begins the case in court. In pre-election matters, this is often done through a process called an originating summons. This method is used when the main issues are about the interpretation of laws and documents rather than disputed facts. The summons must clearly state the questions for the court to answer and the orders, remedies the aspirant is seeking. This document, along with a sworn statement of facts, affidavit, and all the evidence. Section 6. Evidence and practical steps. What aspirants must do to succeed. In any court case, evidence is king. This is especially true in pre-election litigation. A judge is not interested in political rhetoric or emotional appeals. The court wants to see cold, hard proof. Good evidence will always defeat good speeches. Speeches versus evidence. Therefore, an aspirant's primary focus should be on gathering strong documentary evidence to prove their claims. The most useful pieces of evidence include the political party's constitution and its guidelines for the primary. These documents set out the rules of the game. You must show how the party broke its own rules. Other critical documents include the official result sheet from the primary election. You will need a copy of the list of delegates or members who were eligible to vote. Your nomination form and the receipt showing you paid for it are essential to prove you were a legitimate aspirant. Photographic evidence of irregularities at the primary venue can be very powerful. Video evidence of irregularities can be very powerful. Written statements from your agents, other aspirants' statements, electoral officials who witnessed the malpractice are also vital. Every claim you make in court must be backed up by a piece of concrete evidence. Beyond gathering evidence, there are several practical tips for aspirants. First, as stated before, act with extreme speed. Know the 14-day time limit and work towards it. Second, ensure you join all necessary parties in your lawsuit. Do not leave out the party, the rival candidate, or INEC. Third, frame your case clearly. Focus on how the Electoral Act was violated. Courts are more comfortable enforcing a public statute than meddling in what looks like a private club dispute. This makes your case stronger and more likely to be heard. Finally, think about the remedy you want. What is the most practical outcome? Do you want the court to declare you the winner, or do you want the court to cancel the primary and order a fresh one? The relief you ask for must be logical and achievable. For example, if the election is just a few weeks away, asking for a new primary might be impractical. In that situation, it may be better to ask the court to declare you as the rightful candidate based on the lawful votes cast. A well-managed pre-election case built on speed, strong evidence, and sound legal strategy can effectively protect an aspirant's rights and uphold internal party democracy before it is too late. Thank you for watching.